Good morning. I think there's an advantage to going first in that whilst you're nervous in opening the conference, you don't face the problems of being the speaker after lunch when half of your audience are struggling to stay awake. So, let me start. Anti-Semitic incidents have been rising for near on 20 years in Europe, and our European laws and political agreements are clearly failing to dispel European Jews' fears about their communal security, despite the legal and political progress that's been made. In this brief presentation, I just want to briefly look at the general provisions and then at some of the more specific provisions and some of the case law and conclude with a short assessment of their effectiveness. So the UN International Convention on the Elimination of Racial Discrimination and the UN International Covenant on Civil and Political Rights define and outlaw hate speech internationally, and together with the UN Rabat Plan of Action on the Prohibition of Religious and Racial Incitement, they establish the general protections and advice on how states should use them. Within Europe, the Convention on Human Rights, the Maastricht Treaty on European Union, the Charter of Fundamental Rights, and the Treaty on the Functioning of the EU, taken together, established Europe's primary human rights and anti-racism legislation. But in the latter, secondary laws that are especially relevant in combating anti-Semitism. The 2008 Framework Decision on Combating Racism and Xenophobia required EU member states to establish a minimum legal level for criminal incitement based on racial and religious grounds, and denial or gross trivialization of genocide, including the Holocaust. Member states were required to transpose the decision into domestic legislation by November 2010, and the European Commission was subsequently given powers to launch infringement proceedings against those states that had not done so or had done so inadequately. The additional protocol on cyber hate to the Council of Europe Cybercrime Convention required signatory states to criminalize racism, xenophobia, and denial of justice, including the Holocaust, committed through computer systems. This too was later given the legal power of a directive by the European Union, which required member states to transpose it into domestic law. In upholding the legislation, the European Court of Human Rights has issued important landmark judgments, including against inciting anti-Semitism and denial of the Holocaust. For example, in Garadi versus France in 2003, the court upheld the judgment against the Holocaust denier who had disputed the existence of the extermination camps. It noted that denying crimes against humanity was a serious defamation of Jews and was an incitement to hatred. His real purpose, they said, was to rehabilitate the Nazi regime and accuse the victims of falsifying history. And he too was not entitled to the protection of freedom of expression contained in Article 10. In 2007, the court upheld the conviction in Pavel I versus Russia. Ivanov was the author of a series of newspaper articles portraying Jews as the source of evil in Russia, thereby denying them, and I quote, the right to national dignity. There are other cases, I'll just mention two more. In Mbala versus France, the court upheld the conviction against the notorious performer who had invited convicted Holocaust denier Robert Faurisson to join him on stage to receive a prize from an actor dressed in concentration camp pajamas with a stitched-on yellow star bearing the word Jew. The court declared Mbala's appeal invalid as his performance was not entertainment but a provocative political statement designed to demonstrate hatred and degrade Jewish victims. More recently and importantly, the court, or equally importantly, the court upheld the judgments against Udo Pastors, a member of the Mecklenburg-Western Pomerania Parliament, who had argued that the Holocaust is being used by Jews for political and commercial purposes. The court defined the expression of Holocaust denial as, I quote, intentionally stated untruths in order to defame the Jews and the persecution they had suffered. Council of Europe member states, and the distinction between EU and Council of Europe, and we can go into that later if you want. Council of Europe member states are required to follow the case law of the court, and its judgments provide a valuable set of legal precedents. They are also obliged to adopt the guidelines contained in the general policy recommendations published by the European Commission Against Racism and Intolerance, as well as the recommendations contained in its 5-yearly country inspection reports. GPR number 9 provides guidelines to states on the fight against anti-Semitism. Among the recommendations are the need to enact and enforce robust anti-Semitism legislation which penalizes all intentional anti-Semitic acts against actual or presumed Jews, including public incitement to violence, hatred, or discrimination. This particular GPR was published in 2004 and is due to be updated in 2020, and the process starts in 2 weeks' time. In December 2018, the Council of the EU, the highest body, adopted the Council Declaration on the fight against anti-Semitism and invited member states to adopt and implement holistic strategies to prevent and fight all forms of anti-Semitism as part of their strategies on preventing racism, xenophobia, radicalization, and violent extremism. It called on those that had not yet done so to endorse the IRA Working Definition of Anti-Semitism, to improve the recording of hate crime by law enforcement authorities, fully implement the 2008 Framework Decision, reinforce the protection of Jewish communities, improve education on the Holocaust and anti-Semitism, and invited the EC to maintain its focus on combating anti-Semitism. I'm going to skip a little bit because of time. Just go to the IRA Working Definition. This has to be easily understood by first responders, that is, police officers and prosecutors, rather than be a definition for academic use. Also, it had to be used for guidance rather than as a legal instrument, which would require changes in the laws of each member state, and when the 2008 Framework Decision provided a basic law anyway. In 2016, the IRA adopted a modified version of the EUMC working definition of anti-Semitism to sit alongside its working definition of Holocaust denial. So far, 23 states have adopted the definition, albeit in different ways. The European Parliament and the Council of the EU have adopted it and called on all states to endorse it. This September, the UN Special Rapporteur on Freedom of Religion or Belief also recommended its use as a critical, non-legal educational tool. Adopting the working definition, however, is not the end of a process, but only the beginning. Justice is delivered locally, and it is at this level that the definition needs to be used. But again, measuring anti-Semitism to consistent and properly evidenced criminal justice standards remains a problem. The EU high-level group was established to support effective implementation of the agreements to prevent and combat hate crime, and in 2016 it asked the Fundamental Rights Agency to coordinate a subgroup of practitioners to develop methodologies for recording and collecting data on hate crime, including anti-Semitism. Since it began operations, FRA has complained consistently about the lack of consistent disaggregated data, which is necessary, of course, to formulate strategy. The OSCE has also taken this up, and as a consequence of a series of conferences, including in Berlin, Cordova, Bucharest, and Astana, it has provided training for law enforcement officials, both police officers and prosecutors, to enable them to recognize hate crime and to gather and analyze such data. The OSCE also implemented a program funded by the German government, Words into Action, which also covers Jewish community security and education about anti-Semitism. It's been in suspense for the most part of 2019, but starting up again this week. I should have been in Munich training cops this week, but I'm here instead. The second high-level subgroup was charged with monitoring the EU Code of Conduct on countering illegal hate speech online. This had been agreed with the larger networks in 2016, and the implementation of the code is evaluated through regular monitoring exercises by a network of civil society organizations using a commonly agreed methodology. And it's producing real results. Of course, the problem is now migrated to the smaller platforms which are not covered by the Code of Conduct or which resist it, and this remains a challenge which still has to be addressed. In recent months, I mentioned also the UN Special Rapporteur of Freedom of Religion. He has endorsed all of these, as have the first Vice President of the European Commission and the Justice Commissioner. They've recognized the working definition of anti-Semitism as a valuable guide, recommended its use in education, awareness raising, and monitoring anti-Semitic incidents. And the UN rapporteur added that it should be applied in line with the guidance provided by the Rabat Plan of Action and CERD, the Commission on Racial Discrimination. Let me just add a few conclusions as I'm coming to the end of my time. It seems to me that the two basic bits of legislation, the 2008 Framework Decision and the Cyber Hate Protocol to the Cybercrime Convention of the Council of Europe, which EU states are required to transpose, provide good and effective tools for combating anti-Semitism. But the problem is with the states, not with the European agencies or the conventions. By last year, only 16 EU states had operating strategies to combat and measure hate crime, and even fewer had any official capacity to measure anti-Semitism or possess dedicated action plans to combat it. For any laws to be effective, they have to be consistently applied. Criminal justice agencies have to be trained in with practical ways to apply them, and they have to be accompanied by long-term education programs that reach just beyond criminal justice agencies. They have to reach all of society. Combating anti-Semitism is not a short-term project. Given two millennia of anti-Semitism in Europe, it's going to take more than the laws and education for criminal justice agencies to overcome the problem. Given its current concerns, I sometimes doubt whether the EU has the capacity to take forward its legislation and the codes of conduct and all the other agreements that have been hammered out in recent years, which are real progress, but I sometimes doubt whether they have the capacity to persuade states to apply them effectively and consistency. That requires real political leadership and a lot of money at a time when European states have many other concerns. Thank you.